Hello, good friends of the good Lori. Welcome to Children of Darkness and Light. Tonight is our Wednesday true crime, and boy, do we have a lot to talk about today. We're going to talk a little bit more about Bryan Kohberger and the University of Idaho murders. And then I have a couple of other things I want to talk about. There's some new filings in the Delphi case that we're going to talk about, and also missing mom Anna Walsh out of Massachusetts. It's an interesting case, and I think it's going to. I think it is going to be a little bit like Suzanne Morphew, but let's kick off. First of all, I'm going to wait a couple of minutes, just to let folks catch up and realize that we're live, and take care of some housekeeping stuff. We are going to be starting our Quilt Guild any moment now. I'm working on those videos right now, so expect to see them released as soon as I can do the editing on them. And I had a question in chat. Do you need any kind of special sewing machine for our Quilt Guild? And the answer is no. A simple sewing machine that'll sew a straight stitch is all you need to get started. And the first video I've got coming up will be one to talk about equipment, some of the things that come in handy, and some of the things you just can't do without when you're going to make a quilt. So we'll continue to talk about that stuff as time goes on. But in my last video, we talking about genetic genealogy this week, and I was prepared to do that. But there's a few things kind of on the horizon having to do with some current cases. So I thought we'd put that off for a week, and we'll talk about genetic genealogy when there isn't quite so many developments happening in the cases that we're all talking about. So the first thing I want to talk about tonight is the University of Idaho college murders and the suspect, whose name is Bryan Kohberger. So I always like to do a little thumbnail because not everybody is following these cases as closely as all of us are. So just in case you may not have been following the case that close, 4 University of Idaho students were murdered on November 13th in the early morning hours overnight. And for a month and a half, the case, people kept talking about, oh, the case is cold. Then an arrest was made. 28-year-old Bryan Kohberger was arrested at his parents' home in Pennsylvania. And when the probable cause affidavit was released, we all realized that law enforcement had been a lot farther ahead on this case than we thought they were. As it turned out, they had identified Kohberger as a suspect fairly early on in the case, identified, first of all, his white 2016 Hyundai Elantra, were later identified his telephone number, and with those 2 bits of information, were able to put him under surveillance and later develop probable cause for his arrest. So one of our mods just made a good point. Usually I start out by talking a bit about the cases that we are all interested in, any new developments, what I think they mean legally. And then the second half of the show, we take questions. To make it easiest on our mods, if you hold your questions until the second half of the show and put the word question to start in the comments, it will make it much easier for our mods to pull out your questions, because we don't like to miss them, and our chat does move pretty quickly. So back to Kohberger. Bryan Kohberger was arrested and extradited and brought back to Idaho, where Moscow, Idaho, which is in the northern part of the state. Moscow, Idaho, and Pullman, Washington are just across the border from one another. The University of Washington Washington State University. I don't want to make any Huskies or Cougars upset with me over that. Washington State University is across the border in Washington from Moscow, Idaho, and the University of Idaho. People go back and forth across the border frequently, and they're about 8 to 10 miles apart. So Bryan Kohberger was a graduate student studying for a PhD in criminology, interestingly enough. And he was identified fairly early on in the case and then placed under surveillance while probable cause was developed. So there's some kind of interesting developments coming up, and some of them mean that we have to ask, what does that mean? And are we really sure we know what it means? One of the things that happened this week is that some motions were filed to seal some documents. And the kind of odd part about it is this very detailed 19-page probable cause affidavit was unsealed. And yet they just recently asked the court to seal the supporting documentation that they submitted to the court to apply for search warrants for his home and his office at Washington State University. He was a teacher's assistant because he was a grad student. He was a teaching assistant for the school. So the interesting thing is that there were some requests made to, my phone's ding-donging and I'm going to turn it off. There were some requests made to seal those affidavits after the probable cause affidavit was already released. And that raised some interest for people that potentially there were things in those search warrant affidavits that the prosecution and the court did not want released because it might cause a problem with the investigation. So it's possible. The timing is a little odd. And remember, we're dealing with multiple jurisdictions. So we're dealing with Washington State, where these search warrants were applied for, and their procedures may be slightly different from the state of Idaho. So we're dealing with Washington State, Idaho, and also Pennsylvania. So it appears that either because it is common practice or because there's something in the documents that the prosecution is concerned may leak the investigation, Washington State has agreed to seal those search warrant affidavits. It could be nothing simpler than just the difference in jurisdictions, but it could be something more. It could be to protect a witness, to protect to protect the investigation if it happened that they were investigating other people that might be involved. Now, I will say that sealing those search warrants didn't necessarily sort of raise my radar about, oh, they must be looking for another person. But it has raised that radar for some other people who are involved in law enforcement or who follow these cases. I don't think it's impossible, but I sort of think it's unlikely that they're dealing with another person of interest who might be involved in the case. I think more likely this is a difference of timing and a difference of state jurisdictions. So, but we will know more because the court put a time limit on how long those affidavits could be sealed, and they have to be opened the 1st of March unless the court orders the sealing to continue for some reason, and there has to be a compelling reason. So the affidavit says that there could be a serious imminent threat to the, hang on, I gotta read my notes. So the affidavit in support of sealing the documents says that there could be a serious imminent threat to the effective investigation being done by law enforcement. Um, so we don't know at this point whether or not there's information contained in those affidavits for search warrants that is not in the probable cause affidavit. But I point out, if you remember, the court in the Delphi case sealed that probable cause for weeks. And yet when it was unsealed, we all looked at it and said, well, what was the big deal? It didn't appear that there was anything that would have that would have caused problems with the investigation. So it could be sort of another one of those a whole lot or nothing. But we don't know. It could be information that he's of other crimes that he's committed. It could be other suspects or other witnesses. I tend to think it's probably unlikely. I also, a couple of followers sent me information that's come out that he went to a clinic appointment, a scheduled clinic appointment after the murders. Yes, Sarah, I'm still using my OSU cups. Sorry, you can take the girl out of the state, but you can't take OSU out of the girl. People were making something of the fact that he went to this clinic and kept this appointment. I didn't think it was all that unusual. First of all, I think people like this, especially somebody who's got this background in criminology, he's going to think keeping his schedule as normal as possible, attending appointments that he had previously had scheduled. All of those things, I think, would be typical of somebody who was trying to sort of maintain his normal life. There were a couple of things that I did think were interesting. Looking through the documents, the gag order in this case was actually stipulated to, which means the defense and the prosecution agreed to it. Somebody also asked me, how did he get a court-appointed attorney, an attorney appointed for him before he got back to Idaho? And the answer is that the court had the ability to do that once the arrest warrant was issued. So knowing that he was going to be extradited back, the seriousness of these charges, the judge went ahead and appointed counsel for him, presuming, based on information they had from Pennsylvania, that he was going to be indigent, that he would not be able to afford his own counsel. So that was the answer to that. The other thing I found interesting, and I don't know if you can read this or not, the other thing that I found quite interesting about this, about the orders that were issued by the judge in this case. This was an order on courtroom behavior, and it specifically says that there will not be live streams and will not be contemporaneous broadcast of the court proceedings. There will be pictures, there will be video, but it will be done. It will be available after any hearings. Now, I had thought long and hard about the possibility of going to Moscow because, as you all know, I'm living in Idaho for the Vallow Daybell case. I had given some thought to going over for his court hearing that's scheduled tomorrow at 8. I think it's going to be a status hearing to set a preliminary hearing date. So I decided, because the weather is not great and the roads up north are fairly treacherous, I decided that I wouldn't go because I think it's going to be a brief hearing. If there is a preliminary hearing in this case, I will be attending. So we will see what happens. I also thought, looking at the orders and motions to seal from the Washington court in the search warrant documents, the first thing I thought was Judge Boyce could take a lesson from Washington on how to legally seal documents, how to appropriately write orders to seal documents. So I think that's about all on the Kohberger case. I do want to say that there have been some internet sleuthing going on that has uncovered what appears to be posts on a medical chat postings from when Bryan Kohberger was in high school, where he talks about his mental state. He talks about his about having something he calls visual snow, which is apparently a neurological condition. And he also talks about his mental state. Those are out there, but and I'm certain that you can find them. They're out there on several websites. I know that News Nation has had them on their website. So there are also, but there are a lot of rumors and a lot of false information out there. So please, before you disseminate information, before you hit that forward or that retweet button, please make sure that you're confident that that information is correct. For instance, we had another one of those YouTube pirates, I guess you'd call them, who contended that that they had made a recording from a Ring doorbell, which recorded the incident as it was happening. It was a fake. It was proven to be a fake, but not before it went out all over social media. So please, for the sake of the victims, please don't disseminate information unless you are confident that you've gotten it from a reliable source. We're doing our best to only give you information that we think is reliable. It very much appears that that law enforcement is aware of the Papa Rogers posts that were made in the big Facebook group interested in this case, and that it does appear that it was him, and that he was trolling the groups, and so there is information out there that is good and reliable, but it's hard sometimes to tell the difference. So I'm just encouraging folks to be cautious. We're going to continue to be cautious here and try and only share information that is reliable and that we can confirm is actually real information. Because there are a couple of people on social media who have gotten reputations and built followings by creating false narratives in these true crime cases. So we're going to do our best not to perpetrate that, and we're just asking that everybody out there please be cautious about how you share that information. So let's move on and talk a little bit about Delphi. There were a couple of documents that got filed in Delphi, and I actually pulled them up because I wanted to be accurate about talking about them. So if you see me glancing over at my screen over this direction, it's because I'm looking at my second screen to read the document. I didn't download it and to put it on the screen because it's a lot of type and I was concerned that you wouldn't be able to read it anyway. So let me just talk about a few things. In the Delphi case, the defense has filed what's called a supplemental motion for discovery and a request for Rule 404 and 405 information evidence. Now, we have talked before about Rule 404 and 405. We talked about 403B information, about character information. We also talked about Bruton, about confession information. So that is all the types of information that the defense is seeking. Now, the prosecution has an obligation to turn over every piece of evidence they have. So this is sort of a belt and suspenders kind of a motion, so that the defense can say, we specifically asked for all of this information, and we did it with specificity. We asked for particular bits and pieces of information. So one of the things they asked for, which I thought was a little bit interesting, was so it's very typical. They ask for names and addresses of people, any written and recorded statements of any the defendant or any witnesses, any testing that was done. They want to know who did it. They want to know what the results were. But they also ask for what appears to be confidential informant information. They want to know if any person was acting directly or indirectly in the investigation or on behalf of the state. Now, we know in Delphi that there's been a suggestion that more than one person was involved, and that potentially one of the people is, and somebody's going to have to remind me of his name because I can't think of it right now, young guy who is currently in jail for having inappropriate child images, trying not to use the buzzwords that YouTube doesn't like. So inappropriate images of children. So we know that there's been a suggestion that the two of them had some contact and knew one another, and that there's a possibility that they were involved in some way. Keegan Kline, thank you. I knew somebody would be able to give it to me. Keegan Kline is his name. And so there's some suggestion they lived in the same community at one point, that they may have known one another, that they may have tromped around in the same internet circles, if you know what I mean, and that there may have been some connection between Keegan Kline, who admits that he had digital contact with Libby and Abby just before the murders, but denies that he ever had any in-person contact with them. Some other interesting things are that they're asking for the grand jury testimony of a witness once they've testified. Now, in Idaho, grand juries are absolutely sealed, absolutely unavailable to anyone, other than the fact that a transcript could be made available to the defense after testimony. So it appears in Washington, in this case, in Delphi, that there's a similar rule that the defense can get this after the grand jury. Statement as to any consideration and benefits incurred or offered by the state, or that the state intends to offer to a witness. So this goes back to Keegan Kline again. the possibility that they may have made him an offer in order to get him to testify in the murder case. We do know in Keegan Klein's case that that there were some of his charges that were dropped shortly before the arrest was made of Richard Allen. So a lot of people speculate that that may have been part of the deal he made, was to get some of his charges in the unrelated child image case dismissed in return for his honesty and testimony. I think we're going to find out about that, a lot more about that connection as time goes on. So that was kind of interesting. They also asked for overheard statements, which is always kind of interesting in jails. You always have a jailhouse snitch, somebody who thinks that if they listen in on a conversation, that they might get a better deal in their charges if they snitch out the guy in the next cell. So those are always possible too. And lastly, for tonight, I want to talk about this case of Anna Walsh. Anna Walsh and her husband, Bryan. It does seem there are an awful lot of Bryans in this case. Sorry, that image is a little small, but Anna was a realtor, did a lot of kind of upscale real estate, and also did commercial real estate in Washington, D.C. Now, she and her husband, Bryan, and their three children, were living in Boston. And she was commuting back and forth from Boston to Washington, D.C. for work. And according to Bryan, early on New Year's Day, she caught a ride to the airport because she was scheduled to be flying out to DC for work. So 3 days later, her employer calls and says, "We haven't seen her." He says, "I don't know." So the employer calls the police, and then of course Bryan calls the police, because we wouldn't want the employer to call the police without Bryan looking like the worried husband. Now, some things to know about Bryan are he is a purported art dealer, using the term somewhat loosely, I think. He has a history of dishonesty and was currently on house arrest for fraudulently attempting to sell fake art to art buyers. So the police get a little suspicious because he's not giving much information, and ultimately they arrest him for misleading investigators about her disappearance. Now, we all know, because we've seen this before. We saw it in the Vallow case when they charged Lori and Chad with tampering and destroying evidence. It was a throwaway charge. It was a hold charge. It was a charge they could prove at the time, but wasn't necessarily what the ultimate charge was they were looking for. But it got them in jail, got them off the street, and kept them from tampering with evidence. So that's what they've done with Bryan Walsh. They picked him up, took him to the police station. There's a very disturbing video of him coming out of the police station, his feet still wrapped in booties that appear to be to collect evidence. And he's grinning from ear to ear like he's a movie star. So after they arrested him, they got a search warrant and they started searching the home. And lo and behold, in the home, they found a broken knife with traces of blood on it as well as blood in the basement. They also, over the next little while, have turned up some other interesting information. Information that he left in his car, in spite of being on house arrest, by the way, and drove to his mother's apartment and was somewhere in the vicinity of his mother's apartment. So that led them to look through the dumpsters and then to look to the garbage transfer station where the dumpsters had been dumped. And at that transfer station, they found plastic bags full of bloody towels and a hacksaw, a bloody carpet, a hatchet, and clearly some evidence that something had pretty serious had happened. They then started looking through surveillance footage and computer and credit cards and discovered that he had spent $450 at Home Depot for cleaning supplies the night that she disappeared. And then they also found in his computer searches that he had searched how you dispose of a 115-pound woman's body. So it doesn't look good for Bryan. It's interesting that there are reports now that he at some point was in a mental hospital, and that there was a diagnosis of him being a sociopath. There have been discussions, there have been witnesses who have come out and said he was mean, he was physically violent, he was all about the money. There was a court case that he started having to do with his father's estate. His father was a physician, and he was the only child. When his father died suddenly, he discovered that his father had written him out of his will, and he then contested the estate. The reason the father wrote him out of the will was that several years earlier, he had stolen several $100,000 from his father in a land deal, in a real estate deal. So Bryan doesn't appear to be a real nice guy, and I think we're going to hear much more about this case. I think we're going to see some murder charges here shortly, but this again gets back to the question of whether or not murder charges can be proven without a body. And we've talked before about no body murder cases and how difficult they are to prove. So I think they're holding out, hoping that they will find at least some evidence of a body in order to prove that she's actually deceased, because otherwise it is definitely an uphill battle in a prosecution to prove a no body murder. So those are the kind of interesting cases that we've got today. We're right at about the half-hour mark, so I'm happy to take your questions if anybody wants to talk about these cases. I've also had several listeners ask me questions. Several followers send me ideas for cases to follow, so I'm going to be following up on those. One of them is the case that just started again, Mark Jensen out of Wisconsin, and it is the case where he allegedly poisoned his wife with antifreeze. So I'll be looking at that one, and that he was granted a new trial, and so this is a retrial, and so we'll have the opportunity to look at that. The Alec Murdaugh case from South Carolina gets underway next week. I know that Gigi from Pretty Lies and Alibis is going to be there covering it for Law and Crime. And I know that she will be live streaming as much of it as she can, and then doing some lives to follow up in the evening. So if you haven't subscribed to Gigi at Pretty Lies and Alibis, think about doing that, especially right now with the murder trial coming up. Hi, Tommy. Tommy's question is, I was wondering how an attorney could be appointed to Bryan Kohberger before he came back to Idaho to face the judge. Good question. And the answer is that once the arrest warrant was issued, the judge then could appoint him an attorney. I'm pretty sure that they understood from his dealings with Pennsylvania that he'd already gotten a court-appointed attorney in Pennsylvania to handle the extradition. So I'm sure that they understood that he was going to be indigent, wouldn't be able to afford an attorney on his own. It makes some sense in a case that's this complex and where you have extradition issues and a lot of other issues that might come up before he gets in front of the judge. But you'll also see in the court's database, you'll see that there is an order of appointment that follows. So the judge preliminarily made the appointment, and then once his eligibility was confirmed and he was back in Idaho, that appointment was then affirmed. But in this kind of a case, it's very important to get a lawyer and an investigative team on as quick as possible. As you saw, the lawyer was on the scene at the crime scene. She was able to immediately file motions to stop the remediation cleanup that was going on at the property. If you remember, 2 hours before Bryan Kohberger was arrested, remediation equipment and vans and personnel started pulling up to clean up the site. And she filed a motion that immediately stopped. And then the following day, the investigator was there, law enforcement was back, and they were pulling more stuff out of furniture and bedding and mattresses out as evidence. So that wouldn't have been possible had she not already been appointed at the earliest time possible. So it was a good move on the judge's part. And I think that that it goes to making sure that Kohberger has an adequate defense and that his rights are protected by making sure that the evidence at the scene was protected and documented. So Janet asks, were the search warrants all for locations relating to Bryan Kohberger? As far as we know, the search warrants that were sealed related to him and to his apartment and his office at the university. So remember, these warrants were out of Washington. So the only warrants that would have been issued out of Washington would have been for his residence and his on-campus office. So yes, they were all related to him. Oh, Grav Falls. This is a really interesting question. Do I think Bryan Kohberger will have issues having a woman public defense attorney given what we know now? I don't know if we know enough to really know whether he's going to have a problem with a female attorney, because we have suspicions that he has some problem with women. But I don't know that we know enough about what that is to be able to sort of make an educated guess about whether or not he would have trouble having a woman public defender, because he may think that he can charm her. Let's remember that there are many indications that he thinks he is very smart and many indications that he has studied criminology and that he has studied criminal justice. And so he may think that he can charm his public defender. I it strikes me. I don't know. Maybe this is a fair parallel. Maybe it's not. But let me just talk a little bit about Ted Bundy. A lot of people have likened this guy to Ted Bundy, and a lot of other people have said this guy's no Ted Bundy. I'm not going to suggest one way or the other whether there are parallels, but one thing that I will say is that Ted Bundy had a type. If you look at all of his victims, they were young college students, they were attractive girls, they usually were brunettes, they were, he was one of those who certainly had a type. And everything we know about him is that if you didn't fit that type, you were pretty safe with him. For example, author Ann Rule met Ted Bundy. Author Ann Rule really started writing books because of Ted Bundy. She met him when they were both volunteers on a crisis hotline, and they sat next to one another. Ann Rule was older. She was more of a motherly type figure. And she and Ted got to be good friends, and they chit-chatted and they talked at work, and it was interesting because he was never a threat to her because she wasn't his type. She wasn't in his demographic for his targets. So I suspect that this public defender won't be in Bryan Kohberger's demographic. And the other thing is, I think that defendants usually take their public defenders very seriously because they need them. Their public defender has something they need. So, I mean, in 27 years, I don't think I ever had a defendant act inappropriately to me or in any way threaten me because they needed me. And so they were usually very respectful and very straightforward in the way that they dealt with me. Shay Wimmer on Daybell. If it's conspiracy to commit murder, she wouldn't have needed to be there, correct? So her alibi wouldn't matter. Well, to some extent, that's true. So she's charged with both murder and conspiracy to commit murder. And so they're trying to narrow it down. But you are right that the conspiracy to commit murder is a different, separate crime from actually committing the murder. And you are correct that her alibi isn't going to hold up because she happened to be with David Warwick and Melanie Gibb on the day that JJ went missing. I think the most interesting thing about that alibi is them pinning down the location of the children's death, which we have not known before. That was new information that must be in the discovery, and they must have some sort of indication that the children were both killed in Alex's apartment. Because up until now, they have not, the prosecution has not released that information. It's not said where the crimes actually happened. So. Lynn Bowen. So when given a public defender, the defendant doesn't get to pick, but they get whomever they're given. Judge or someone else determines whom they're given. That is absolutely true. There are some rare occasions, such as a lawyer who has previously represented a defendant in a case that might be related. There are times that the public defense services might reappoint that lawyer. Or the lawyer might ask, hey, I've represented this person before. This is a kind of a related case. How about if you appoint me? Those are things that make sense from a standpoint of the lawyer not having to maybe get completely up to speed on as if they didn't know the case. But in general, it depends on it. The process varies from state to state. In some states, there is a state agency that keeps track of, approves expenditures, keeps track of who gets appointed, and sometimes it's the court. Sometimes it's a combination. In where I practiced in Oregon, it was a combination. So the state coordinator worked with the court, and the court had a schedule. The court had a roster of lawyers and a schedule for which of the groups that the lawyers belonged to were going to be appointed. So in Oregon, we had a public defender, and then we had two groups that were consortia of sole practitioners. That's what I did, who had banded together to have a contract with the state. So in that case, the judge would say, it's Bend Attorney Group's week to get appointments, and so I'm going to appoint them. And that we would have a lawyer there to represent the group, and they would pick up all the appointments, and then attorney assignments would be made. In complex death penalty cases, it's typical for the organization to make sure that they're appointing someone who's qualified. And certainly the judge has a roster of the capital qualified public defenders that could be available. So I've seen the list of capital qualified public defenders for the state of Idaho. There's about, it changes a little bit, but about 25 to 28 people on the list. Some of them are approved to be lead counsel, some are not. Some, like in the Daybell case, both Jim Archibald and John Thomas are qualified to be lead counsel. What that means is that they have sat in as an assistant or a second chair on capital cases before, and they have to do that so many times before they're qualified to be the lead counsel. So the short answer, since I've given you a really long roundabout answer, is that they don't get to decide who their public defender is, but it does have to be somebody who is qualified, who meets the minimum qualifications for public defender for that particular level of crime. So for capital crimes, it would have to be one of the 25 or so people that are on the state roster. Interesting questions tonight. Question, would you be willing to compare Boyce to the other Idaho judge for the Idaho 4 case once both have gone to trial and as motions are filed? Sure. I am particularly interested because my experience with Idaho judges is limited at this point to Judge Boyce. I'm interested to attend some of the hearings for Bryan Kohberger and do a little comparison. Moscow's not a big jurisdiction. They've already proven to be, from an investigative standpoint, head and shoulders above Rexburg. So it's going to be interesting to see from the court perspective what's going to be different. And I absolutely will be looking at how they're different. Emily Louise, do I think Ted Bundy would have been caught sooner if he were around today? You know, I think it's likely. And I think there's been some really interesting discussions. Joseph Scott Morgan, who does the great podcast Body Bags, he is a death investigator, medical investigator, and talks a lot about about scientific evidence. And let's remember that when Bundy was caught, one of the most significant pieces of evidence in the Florida case were bite marks, were bite impressions, because he bit one of his victims hard enough to leave teeth imprints. And now we have DNA. I mean, just having somebody bite somebody would be a field day for DNA evidence. At the time that Ted Bundy was caught, there was not that. We didn't have DNA evidence. So yeah, I do think that he would have been caught much sooner, because he would have deposited DNA on his victims. Before I get to this question, I want to remind everybody, please subscribe if you haven't. Please hit the like button if you haven't. We appreciate you hitting the like button, because it helps our standings with the algorithms. And please, please, please subscribe. We are going to have a hearing on the 19th of January in Rexburg to determine a lot of, the judge is going to decide a whole bunch of motions. Included in that is going to be John Pryor's motion to continue the April 3rd trial in Daybell. I don't think that he's going to grant that. And I think we're going to have a trial that's going to start in April. And so I want to encourage everybody. Right now we're doing Wednesday, Friday, and we're trying to be really reliable about where you can find us. But once the trial starts, we're going to be going live every opportunity we have to tell you what's going on in the trial. That's going to be especially important for all of you if, as we expect, Judge Boyce is going to continue the ban on cameras in the courtroom. So please, please subscribe, hit the notification button so you get notifications when we go live, because I guarantee you we're going to be going live a lot once the trial starts on the 3rd of April. Now, back to this question. Oh, and the other thing I wanted to mention, what brought it to my attention was a super chat that just came by. Thank you so much for all of you who generously donate. And I want to remind everybody that all of your donations, whether they're PayPal, and the PayPal link is in the description, or by Super Chat, all of those donations go directly to our moderators. And they appreciate so much your generosity. I couldn't do this without them. I appreciate them more than they know. And so I encourage you, if you can, drop them a little change for a cup of coffee. Now, KMW208 Life. Question: have I researched the Idaho judge for the University of Idaho case? And if so, what are my thoughts? I saw her do the preliminary hearing. I have not researched her, but I will, because that's a good question. And I would like to know more about her. If she is going to continue to be the judge on the case, then I think it's important that we know what her background is and what we can expect from her. My first impression of her was that she was quite straightforward, very no nonsense, very clear in her discussions with him, very typical colloquy of, do you understand? Have you had time to talk to your lawyer? Very, very, very typical sort of a preliminary hearing. So, but I will look it up, because we should know that. So I will be doing my best to travel. I don't know at this point whether I'm going to be able to go to Rexburg on the 19th. I'm hoping so. It sort of depends. We've got a car in the shop right now, so it sort of depends on transportation issues, but I would like to go, because I think that's going to be an interesting hearing for both Lori and Chad. Story Harmon wants to know, Papa Roger stressed the theory that DNA had come from a sheath left behind. Do you think it's possible he left the sheath intentionally, wanted to be caught, play the mind game. You know, I've thought about this, and I don't think so. I think this was purely a mistake on his part. And that mistake is the reason why I think this was his first offense. I think that he didn't realize I don't want to be overly explicit, but the mental chaos that goes on in that kind of a scene. I don't think that he understood or anticipated the frenzy that would happen. And I think that he dropped that sheath in the thick of that. And it was not until he left that he realized he didn't have it. The probable cause affidavit says it is very likely that he came back to the scene at around 9 or 9:30 in the morning. And I think he came back hoping that he could go back and recover it. I think he got there and he realized it was too daylight, there was too many people, it was too dangerous, and he decided not to do it. But he knew it was there, and so later on, he then, to try and make himself seem like an expert or an insider, he then dropped that bit of information in the chat. I mean, the mental process as well. In order to prove that he was an expert, he was claiming that he knew someone who was close to the case and that he was getting his information from someone who was close to the case. That was his claim as Papa Roger. But I think I think he couldn't resist trying to be the expert, and that meant that he had to say something nobody else knew, and that was to drop that idea that the killer had dropped his sheath from the knife. I think it was funny that a lot of the posters who were in the chat kind of laughed it off, like, yeah, right, dude. They didn't, the folks who were already in the chat thought that was kind of a crazy thing for him to be suggesting. So I don't think he wanted to be caught. I don't think he did it purposefully to play mind game. I think that he underestimated the environment and the frenzy that was going to go on. And I think he just left it accidentally. And, let's remember that he was in that strange, heightened emotional state from culminating what he'd been planning. So, how much do I know about Bryan's defense attorney? I know that she's very experienced, that she's been practicing in excess of 20 years. She's in her 50s, and I know that she's very well thought of in the community, in the legal community. And I know that she was responsible for getting a client. I'm not sure whether the client was acquitted or whether the conviction was overturned, but was responsible for a not guilty verdict based on law enforcement misconduct. She was able to prove that law enforcement had misrepresented the crime scene, had misrepresented the evidence, and was able to exonerate a client that was not guilty. So I know she's very experienced. Beyond that, I don't know her. I don't, but I hope to know a lot more about her. Goldilocks monster. Question: the motion for settlement and strategy meeting, that Lori wants to set up, do you think that's to discuss a divorce or a plea deal? It is not to discuss divorce. There's no way a judge would be allowing them to have a four-way settlement conference on a divorce. It's not. What it is a session to discuss a plea. I think that's pretty clear from the documents that there are settlement discussions happening. And so I can see why her attorney and probably opposing attorney would want to have a joint settlement meeting to discuss whether or not the two of them would take a plea deal. And that plea deal would have to be something that they both could agree to. They would have to agree. They wouldn't both have to agree in order for either one of them to take a plea. I think that their attorneys believe that getting them together to discuss that plea would make that plea agreement more palatable, if that makes sense. They would be able to discuss the plea and try and determine what that was going to look like for both of them and what it would mean in terms of them having what admissions they would have to make. So it makes sense from a lawyer point of view to try and get the two of them in the same room and to have a conversation about the substance of a plea. That to me made perfect sense. I don't believe that it has anything to do with them divorcing, nor do I think that a judge would ever allow that kind of an agreement if it were to discuss divorce. I think that it has to do with their plea offers on the table. And I think her attorney wants to have a conversation about how the two of them can, for lack of a better word, get their story straight. How the two of them can have a unified narrative going forward with a plea. So, and I would not be at all surprised to see a plea. There's a lot at stake in this case. And I don't know whether either one of them really are prepared to face a death penalty trial. Ladybug Lady, question, can a judge be found ineffective? Well, there are ways that a judge can be found ineffective. Usually what happens is that there is a complaint filed with the Judicial Fitness Board, which is a committee from the Supreme Court. And that committee would investigate whether or not the judge was fit to be on the bench. And then the panel would issue a decision. In general, judges are not found to be unfit unless there is some serious mental health, drug and alcohol, substance abuse issue. And judges are generally, it is difficult to get a judge off the bench for any other reason. I've heard of judges being booted from the bench because of making racist or sexist or anti-LGBTQ. I don't know why I have such a hard time with that, but anyway, making comments that are personal or are offensive. But in general, the Supreme Court is not going to intervene and ask that a judge be removed from a case. That is left up to the Supreme Court and to appeals. So the way that it works is that if a judge isn't effective and issues rulings at trial that are incorrect, then those rulings would be contested and appealed, and the defendant would be asking for a new trial. So I don't believe we're going to see a situation where Judge Boyce is going to be removed from the Vallow trial unless he does it voluntarily. So, Grav Falls. Okay. Question regarding a plea deal. Do you think the prosecution would really offer a plea deal, and what would that even look like? Yeah, I think the prosecution would offer a plea deal. Here's why. Given a lengthy 10-week plus trial, because remember, that estimate for a 10-week trial includes 2 weeks of jury selection, 8 weeks of trial, does not include the penalty phase. So we're talking about 10 weeks just to get to guilt or innocence. If they're found guilty, then we're talking about another 2 to 4 weeks of penalty phase, where the defense puts on their mitigation case and the prosecution puts on the case for why they should be put to death. So we're talking months and months and months. We're talking, and I think it's important that the prosecutor's always looking at it and saying, you know, I have a really good case, but never when you go to trial is it 100%. So there's no such thing as a slam dunk. There's no such thing as 100%. The jury could go their own way, and you could end up with an outcome that you don't expect. So given the choice between a sure thing and going forward to trial, I think the prosecutor's always going to take the sure thing. And I think what that looks like is life in prison without parole. And I think what's sticking them right now is the issue of parole. What we know in Idaho is that unless you get life, specifically are charged with the death penalty and it gets dealt down to life without parole, parole is presumed. So I think that's probably the sticking point. I don't think that the prosecutor is going to make any kind of deal that includes parole. And so I think what's happening at this point is her attorney asking for a 4-way discussion to sit down and talk about what does that really look like? What ultimately does that plea look like? So I do think that prosecution has offered him life without parole. Oh, Bo Pete. Question, can Chad have Judge Boyce removed the way that Lori had Judge Edens removed? I don't know. My recollection of what was going on with Judge Edens was that he had previously presided over the guardianship case. If you remember way back in the annals of this case, in the history of this case, when Kay and Larry Woodcock initially were looking for JJ, they asked the court to award them guardianship of JJ. At that point, they were hoping that JJ would be recovered safely, and rather than have him end up in foster care somewhere, they were sort of creating that guardianship safety net so that he could be placed directly back with them. Unfortunately, it didn't turn out that way. JJ and Tylee were dead long before Larry and Kay filed that guardianship. But it was Judge Edens who presided over that guardianship and over those arguments about the guardianship. And so Lori's attorney at the time moved to have him removed for cause because he had a conflict. And I think that was the reason why he was removed. Yes, you can file a motion to have a judge disqualified if you believe that that judge is biased against you or has some sort of conflict, either personally or professionally. I mean, a lot of times judges get disqualified because they used to be prosecutors and they formerly prosecuted somebody who now they're overseeing the case. So there are many reasons why judges can be disqualified. I think that if they had a basis to disqualify Judge Boyce, they would have done it already. I don't think either side is particularly thrilled with the way that Judge Boyce has conducted the case. I know John Pryor isn't happy with the way that Judge Boyce has conducted the case because it's in all his pleadings. So I think that if they had a basis, they would have used it already. And I think they probably just don't meet the minimum legal requirements in the statute to disqualify him. We're a little bit over an hour. I like to keep our get-togethers to an hour. We'll be back on Friday at 6 Pacific to talk more about about Lori Vallow and the Vallow Daybell case. So I hope you'll join us then. I also want to encourage you, if I don't answer your question, if we haven't caught it in the chat, please put it in the comments below or email me. That's in the description. And also you can email me your questions at info@thelorivallowstory.com. If you subscribe to the newsletter, sometimes I answer follower questions in the newsletter as well. I try really hard not to duplicate what we do on Wednesday and Friday nights with what's in the newsletter, but we do definitely go more in depth in the newsletter. We talk about statutes and about cases, and we do kind of get more in the weeds when we're in the newsletter. So please subscribe to that if you haven't. Please subscribe to the channel if you have not done that. Please hit the like button so that we start to move up a bit in the algorithms. And please hit the notification bell, because we're going to have a lot of unscheduled lives coming up in the next couple of months once the Vallow case starts. Thanks tonight. Thanks for joining us tonight. Thank you, Janet. I appreciate all of you. I appreciate all of my followers who do have such smart questions, and enjoy getting the chance to chat with you twice a week. It's a real pleasure and a real honor for me. And once again, I want to thank my mods. Couldn't do it without them, Brenda and Michelle. And want to remind you that all of the donations that come into the channel, Super Chats and PayPal, go directly to them. Thanks for joining us tonight, and we'll see you on Friday.